oriented law as compared to Vishakha, and having a policy. So most of the organizations have a policy and committee in place, and they think that this is good enough, and then they fear that people will misuse the law. If you don't sensitize the employees, because that's the core of this thing, policy and in having an internal committee comes into place only when there is a redressal mechanism. So therefore this is not sufficient. Sensitizing of employees and of the committee member skill building, I think so, is the key as far as this entire law is concerned. This is my last slide. So basically, salient features of the law. Why this law is good for society? First of all, I'm thinking safety of women is anyway good for society. It is good for the organization. And then if you don't believe in the good, this is mandatory by law. So you have to do it whether you like it or not. So what are the salient features? Here, the woman has to make a complaint within 3 months. Okay, from the date of incident, or 3 months from the date of last incident. In case for some reason, because of physical or mental incapacity or some any other reason, she is unable to make a complaint, the committee can at best extend that period for another 3 months. So within 6 months she has to make a complaint. So this is to take care of the concerns of all parties, that tomorrow at the time of appraisal or 2 years later you fought with somebody, they cannot come around and say he sexually harassed me 3 years back. So this is basically, I think so, to make sure that there is balance. One understands that the next day you cannot be expected to make a complaint, but 3 months is a reasonable time for you to gather your composure and make a complaint. And if you believe that in 3 months you don't want to make a complaint, then I'm saying sorry, possibly don't make a complaint. If supposing something comes up again, you can obviously make a complaint then. Confidentiality, one of the very important provisions of this law. Under this law, all people who are involved in the redressal process are bound by law to keep everything confidential. Not only what happened during the committee meetings, but even the identity of the woman, the respondent against whom the allegation is made, and the witnesses. Now this element of confidentiality is not there in criminal law. You make a police complaint, tomorrow everything is in the newspaper. So this is again very important feature of this law. There is a time bound redressal. The inquiry has to be completed within 90 days. In criminal law you can never that kind of prompt relief. This is again good for both people. For the woman you get prompt remedy. In case you believe that this is a false complaint, the cloud on suspicion on the male or the respondent, I'm not saying, I'm just using it for a reference purposes, that male being a respondent, that the cloud of suspicion gets removed. So basically the shorter the time, you know, doodh ka doodh, pani ka pani, whatever is coming quickly will come out in the domain. Again, even after it comes out in the domain, by law you're not required to disclose the identity. You take action. The idea is to take action, not to malign the name of the people concerned. Monetary compensation is payable by the respondent. In the US you would hear every time there is a sexual harassment case and it is proven, the company lands up paying money. This is like an insurance policy for the organization. If you've complied with all your obligations, there is no obligation on the organization. In case it is proved that the woman was actually harassed, the monetary compensation is payable by the person against whom the allegation is made. So very frankly, this is an insurance policy. In case you don't do it, there have been instances where the company has to pay damages personally by the management as well as the organization. Principles of natural justice, very important feature, just 4 words, but it makes a lot of difference. Under principles of natural justice, the burden is on the person who makes an allegation. So if the woman says that she has been sexually harassed, she has to prove the initial burden, whether direct evidence or circumstantial. I'm saying that if you actually write your complaint properly, in detail, the committee will be able to understand what you've gone through. So as again Shireen mentioned, IQ and EQ, as long as you tell your complaint in detail, just don't say 6 months back he harassed me, because that person also has to know what is the allegation against him. So you have to be precise, which day it happened, what happened, were there witnesses, is there any supporting document, and all of that is required by law. It's not something which I'm just saying for the heck of it. All that has been put in the process itself. Burden of proof, again very important feature. Under this law, in civil law you have to prove probability, under criminal law you have to prove beyond reasonable doubt. If you complaint before the internal complaint committee amongst peer group, where the burden of proof is much lower, it is impossible for you to win before the police. So again, this is a very important feature. Again, women normally don't want to go to the police, but even if they are inclined to go to the police, they have to understand that if they can't win here, they can never win there. Punishment for false and malicious complaint. Again, as I said, this is a double-edged sword. So if you make a false complaint, and mind you, not being able to prove a complaint doesn't mean it's a false complaint. So it's not either you are right or I'm wrong. It's basically that there can be 3 options. One is that the woman is right, because which action can be taken against the respondent. The other is the woman is unable to prove a complaint. She's made a complaint, but as a committee you are unable to decide who's right, who's wrong. In that scenario, you will close the complaint saying that because of inadequate evidence, we are closing the complaint. That does not mean it's a false complaint. It's only when the committee comes to a positive conclusion that the complaint is false, will action be taken against the woman. So this is again done so that women can make a complaint. So it is just because you are unable to prove a complaint doesn't mean your complaint is false where the company can take action against you. But supposing you say that he sent me, he wrote a love letter to me or an obscene letter to me, and it is proven that that letter was forged, he had not sent it. That's proven forged document. In that kind of an occasion, action can be taken against the woman. Again, another feature in this which is not there in the Vishaka guideline, there is an appeal provided before the industrial tribunal. Government organizations will have service rules. Based on service rules, wherever your appeal is provided, you will do that. In case where the service rules are not there, then the appeal is provided to the industrial tribunal. So in case, despite all the deterrent and all the procedures provided under the law, you're not happy with the outcome of the recommendation of the committee, in that case basically you can challenge that recommendation before the industrial tribunal, whoever is aggrieved by that, and the industrial tribunal will hear the entire matter afresh. So basically you cannot bring new evidence. Whatever you have to say or do, you have to do it in the lower court, but they will look at the entire evidence again. So in case if the committee has by mistake forgotten to consider some facts which can be so material, then the industrial tribunal can actually go and set aside that order. Basically this is an appeal on facts. If people who understand law, here under this law you have one remedy of appeal on facts, whereas in Vishaka there was no appeal on facts. It was directly by way of a writ petition, where it was only in case of violation of principles of natural justice, something which was so I would say wrong that the High Court wanted to interfere, which could do that. Again, another important feature is conciliation. At times what happens is the lady wants the thing to stop, but the person does not take it seriously. It's like, okay, she's saying just no, 10 times if I pursue her she'll say yes, but she gets so petrified or so harrowed by that thing, she makes a complaint. She doesn't want to take it to the logical level of inquiry, etc. In that scenario what happens is basically there is a provision for conciliation also. So it's like an alternative dispute mechanism. She's made a complaint. This conciliation request cannot be made by the respondent. Only if the aggrieved woman wants to conciliate should conciliation be even attempted. So if both parties agree, so he says no, I've got my message now, I'm sorry, and she says okay, then I want to withdraw the complaint, then the committee can record that by conciliation they have decided the matter and the matter can be closed. Another important feature is interim relief. The lady has made a complaint, but despite that you have to face each other every day. That can become very uncomfortable as far as the people are concerned. What do you do in that scenario? So the law provides basically that the committee in its wisdom, keeping into account the wishes of the woman, but if it is practically not possible, there are several options provided. One is transfer the woman to some other location, transfer the respondent to some other location. If either of the two is not possible, send the woman on leave. This is paid leave in addition to every other leave. And if it is an educational institute, because a lot of hotels would also have an hoteling, college, etc. along with that. In that case, that the professor, if it is a professor, then the professor cannot oversee the learning of the aggrieved woman, basically. So all this has been done during the inquiry process. So if the inquiry is over, obviously the interim relief has to go over. So that is there. The last four things are basically just to understand what can be sexual harassment, what cannot be. Quid pro quo and hostile work environment are two types of sexual harassment. Quid pro quo is basically asking for sexual favor, either for the benefit of your career or for detriment or for future prospect. You are asking a new joinee that if I don't get anything in return, then I'm not going to employ you. So basically that is quid pro quo. Hostile work environment could be anything which creates hostility. So supposing in a cafeteria people are sitting together and joking and they're making all obscene jokes. Now that becomes a hostile work environment as far as the other women who are present out there. So even that can constitute a sexual harassment. So these are two things. The most important thing is unwelcome. As I said, for some women sexy could be a compliment, for some for others it may not be. So it is unwelcome to the woman. Basically what is important, it should be unwelcome to the woman, and if anything could be unwelcome to the woman, but the committee is going to decide whether a reasonable woman would have found it unwelcome. So it is unwelcome to the standard of a reasonable woman. not a reasonable person, because a reasonable person includes a man also. So it's basically about a reasonable woman. And the second thing is intent versus impact. You may be complimenting somebody, but if it has a bad impact, it may amount to sexual harassment. Again, when we said, like, you may have people who are joining you from tier 2, tier 3 cities. They come from a different background, economic or otherwise. They see, or they have, I would say, their behavior patterns may be different from as compared to people who are from urban cities. So in the younger crowd, hugging each other could be the norm of the day. Maybe a tier 2, tier 3 may not be comfortable with that. So you have to be cognizant as to what is the perception of the other person and do it. You are doing things at your own risk. So I think so when we do sensitization, we tell them that people come from different behavior, and if you feel you're very friendly, she may not get offended, fine. You may send a double meaning joke on WhatsApp. Some girls may have a hearty laugh. Some people may feel offended. At the end of the day, it is your judgment to decide who you should send that to. So I think so that is something one has to understand. Obligations, as I said, so on the left hand side, I think that we've taken through most. In case you don't comply as an organization, so it is basically an offense against the management. It is heard by a criminal court. Okay, there is no imprisonment under this law, but it is heard by a criminal court. At the first instance, you can be fined up to 50,000. This fine is not to the company, it is to the management personally, and in subsequent violations it can be double the penalty and cancellation of the business license. That is it. There has been instances, now this law is in addition to other laws, so there have been instances where because sexual harassment is also a criminal offense, so there is something called abatement of an offense. If you are required by law to do something which you don't do, then indirectly, because of your omission, you have actually abated the offense. So there has been an instance last year when in one financial institution they did not have the remedy etc. in place. The lady made a complaint to the magistrate, and the magistrate directed an FIR not only against the person who harassed her under 354A, which is the new section under the law, but also against the entire board of directors of the company for abating the offense of sexual harassment, because they had to ensure all these things had to be done, and because it was not done, therefore it was sexually harassed. So they were charged. Now they are in Bombay High Court, they've got anticipatory bail, but they are still fighting that case out. And the other thing is basically one company in Madras was fined 1 crore 68 lakh rupees for not complying with the law. That company did not have an internal complaint committee in place, so the court held that if you had an internal complaint committee, justice would have happened within 90 days. Because you did not have an internal complaint committee in place, the woman had to go door to door, because of which there was a loss of career opportunity. She was a senior woman in that organization. Her severance package was 1 crore 68 lakh rupees. So the court says that in addition to the severance package, you will get damages payable by the organization to the extent of 1 crore 68 lakh rupees. So therefore you have to understand that consequences can be severe. You can obviously wait till you are affected by it, but basically again in this day of social media etc., and especially again hospitality, I don't think so one can afford to do that. And so these were the examples. So our thing is, if you comply with the law, it kind of shields you from any legal consequences and ensures prompt remedy. So last slide, complete code by itself. It puts the onus of the workplace owner to help the aggrieved woman seek redressal. Any law can be misused. The solution is to create deterrent from misuse through an empowered internal complaint committee. Law provides adequate deterrent. Aggrieved woman can again you can again go for defamation etc., all that in addition to this law as well. Government can always make it gender neutral at a later date. And our belief is that instances of sexual harassment can be reduced by 80% in case this is implemented by all organizations in all workplaces, because like our family members would be working somewhere else, and so would be the case. So if all organizations do the sensitization and implementation, India would be a better place for women to work. So that's it. I think so. Thank you so much.